Ready, start. What emerges from the above is that the activities that the custodian or his authorized person carries out vis-a-vis the enemy, such as the business of the enemy or in respect of managing the enemy property, would also clearly indicate that the custodian of the enemy property holds the said property in trust or as a trustee and not as an owner of the enemy property or by exercising rights of ownership over the enemy property. Full stop. The custodian of enemy property for India, who acts on behalf of the enemy, holds in trust the enemy property vested in him under the provisions of the Act. Full stop. He does so as a trustee and therefore, the principles and legal doctrines applicable to a trustee are applicable to the custodian accordingly. Full stop. It is trite law that a trustee or custodian in the instant case can never be the owner of the property. Full stop. The vesting of property in a trustee or the custodian which, in the instant case, is enemy property as defined under the Act is for the purpose of managing the said property and protecting it, so that the property does not fall into the hands of trespassers or unauthorized persons or render it as being ownerless and therefore, a free for all, so to say, owing to the absence of the owner. Full stop. The object and purpose of the act is to ensure that the enemy property, which vests in the custodian, is held in trust and is looked after, protected and managed as per the provisions of the act. Full stop. The statement of objects and reasons of the act makes this position clear. Full stop. A discussion on the aforesaid provisions under the Act would indicate that the custodian takes charge of the enemy property which vests in him by operation of law. Full stop. In the context of acquisition of certain area under the Ayodhya Act, 1993, it was observed that the vesting of the disputed area in central government is limited, as a statutory receiver with the duty of its management and administration. Full stop. According to Section 7 of the said Act, till it is handed over in terms of the adjudication made in the suit, the word single inverted comma west single inverted comma close takes varying colors from the context and the situation in which the word is used in the statute. Full stop. Under the Land Acquisition Act, 1894, vesting in the state, is from the date of taking possession under sections 16 or 17 within bracket 2, which is free from all encumbrances. Full stop. But under the Land Reforms Act, like abolition of states and taking over thereof, the vesting takes effect from the date of publication of the notification in the official gazette until the occupant of the land is granted the occupancy rights. Full stop. This is, however, not the position when the enemy property vests in the custodian under the provisions of the Act. Full stop. The vesting of enemy property in the custodian is not free from encumbrances. Full stop. Therefore, the expression single inverted vest single inverted close has no fixed connotation. Full stop. It is a word of variable input and therefore has to be understood in different contexts and under different circumstances. Full stop. Therefore, the context and situation in which the word is used in the statute is significant in order to interpret the said expression. Full stop. Under certain statutes, the word single inverted vesting single inverted close would mean placing into possession and not conferring ownership of the person who comes into possession of property. Full stop. Therefore, the word single inverted vesting single inverted close is a word of variable input and has more than one meaning which must be discerned, and the exact connotation must be found by looking into the scheme of law and the context in which it is used. Full stop.